Okay. Good afternoon, everybody. If I could just get a check from my panelists, you all can hear me, you all can see me, I can see you guys. Yep. Awesome.
Good.
Thank you so much, everybody, for being here today. We are starting to build our audience. Thank you, everyone, for being here. We are also streaming live on, on Facebook. So if you are watching on Facebook, feel free to drop your questions and comments in the chat there. I'll be sure to monitor it during our session. Additionally, for those of you that are on Zoom, feel free to use our Q&A tab, as well as our chat feature will be interactive through this entire presentation. I am so thrilled to have everybody here today. So thank you, Frank, and thank you, Stephen, for being with us. I'm excited to talk about intellectual property. We will also have a special guest being with us this afternoon. After you guys present, we have Kelly Henry. She is a representative from the Penn State Intellectual Property Clinic that's going to talk about how people can implement some of the things that you guys talk about today through Penn State's clinic. So without further ado, I would like to thank everybody for being here on behalf of the Hazleton Innovation Collaborative, or THInC as we call it. So members of THInC consist of the Greater Hazleton Chamber of Commerce, as well as the Downtown Hazleton Alliance for Progress, the Penn State Hazleton Launchbox in our downtown, as well as Can Do and Can Be. So we are a growing partnership that's looking to forward entrepreneurism through Northeastern Pennsylvania, but specifically through our talent in Hazleton. So we are today here with Frank Vito and Stephen Seach. I'll give you a little introduction on each of them, and then we'll pass the baton over to them. So Frank is the founder of Vito Law, LLC, based in Philadelphia with an office in Hazleton. In his practice, he advises startup emerging growth companies and acts as outside counsel to small businesses and closely held corporations. He also assists and supports his clientele in a variety of commercial transactions, intellectual property, estate and business succession planning matters. Frank is a Hazleton native and the son of local business owners. So thank you so much for being here, Frank. And Stephen is also a Hazleton native and the son of attorney Steve Seach, who I believe joined us this afternoon. So thank you for being here, Steve. He is currently working as an independent contractor patent practitioner for an intellectual property law firm in New Jersey. Stephen is a 2020 Hofstra law graduate awaiting admission to the New York State Bar. As a patent agent, Stephen has worked primarily on chemical engineering and mechanical engineering inventions. So thank you very much, both of you, for being here. I am going to turn it over to you. Let me share the screen and get the controls over to Frank, and we'll be off to the races.
Perfect. Thank you, Jocelyn. That was a great
Thank you so much.
Yeah, thanks everyone for joining, and thank you to Jocelyn for coordinating this, and thank you to Stephen for joining us. I think it's going to be a really cool webinar. A lot of good stuff we're going to talk about, and just to kind of give you a quick intro on how we're going to work it, I'm going to take the first two types of intellectual property we're going to be discussing, and then Stephen's going to take the back half, and then we're going to open it up for Q&A at the end of some discussion. But at any point, interrupt me, drop your questions. I know Jocelyn's going to be moderating that and make sure I don't miss anything. Want to keep it informal. I want to keep it as conversational as possible. So don't be afraid to, if anything pops up, drop it in there, and we'll try to figure it out as we go along here. So cool. So intellectual property. It's a great topic, and it is a topic that is becoming more and more important in our digital world that is increasingly becoming more digital as we see the past 9 months. Everything is, we're predominantly online, and protecting your intellectual property is increasingly important for entrepreneurs and small business owners. So we're going to dive into all four topics today, give you a broad stroke of what each tool is, and hopefully send you forth with some good information that you can implement into your day-to-day operations and protect and grow your business. So cool, let's hop right into it. Jocelyn, do I have access to...
Yep, you should be able to. Are you moving?
Let's see. I'm not seeing it.
Okay, well, we can just be innovative, and I'll take care of it.
Additional control here. Okay. Yeah, you can. I'll just cue you. It's
all right. Perfect.
All right. So to get us started, what is intellectual property? What exactly are we going to be talking about today? So generally speaking, IP is a bundle of property rights that protects the creations of your mind, hence the term intellectual property. So just like your home may be a real property, intellectual property protects everything that comes from your intellectual creations. And as I state there, these rights are crucial for your business. Not only can they be used to protect your creations, but they also can help you get a commercial advantage and be exploited commercially to, open up different revenue streams and allow you some different creative avenues to utilize some of the tools we're going to be talking about today. And just an important point I put there in bold because in my practice I advise a lot of technology companies, and on the flip side I advise a lot of small businesses, and I'm a son of a small business owner myself. And there's this common misconception that IP is only reserved for these high growth tech companies you might see on the news taking on millions in funding, and that cannot be further from the truth. Intellectual property applies across all industries, all business sizes, all business types, and every business I found in my practice, in my experience working with my family's ventures, every business has some form of intellectual property. So throw that notion out the window that if you're not a tech company, you don't have anything to protect, because you have valuable stuff that you're working on that can be used to, again, protect and grow your business. So that's quick intro to IP, creations of the mind. Now let's dig into the different types of protections. So here we just have a quick chart laying the land of the 4 types we're going to be discussing. Again, I'm going to be hitting on trade secrets and trademarks, and then I'm going to be passing it over to Stephen to discuss copyrights and patents, which is going to be his area expertise. So trade secrets, just really quick to run through them. Trade secrets protects your secret information, and I'm going to talk about how all-encompassing and really easy. This is honestly the most overlooked and underutilized intellectual property protection tool I've found. So we're really going to be hammering in on that and discussing how you can really start, discerning some of your trade secrets today. Trademarks protects your brands. As we know, everything's online. Brand protection, brand recognition, brand loyalty. It's kind of like some buzzwords, but it's a huge part of any venture these days. Consumers are much more knowledgeable. They have the ability to reach a wider supply of companies for what they're trying to do business with, or a product or service they need. So brand recognition and brand loyalty is increasingly becoming more important. Copyrights protects works of authorship, often referred to as the author's rights. And then patents protects functional or ornamental features in the form of usually inventions. So yeah, those are the 4 types we're going to be covering today. And then the first one up is going to be trade secrets on the next slide. All right, trade secrets. So what is it? So I'm not gonna read verbatim off the slide, and no one likes to be talked at like that. So practically, with trade secret protection, you can protect any information that is valuable to your business that you keep secret. All right, now that sounds pretty broad, and it really is. And again, this is often overlooked and often underutilized, especially in the small business context. Trade secrets can take several forms. For instance, a trade secret can be a formula, it can be a pattern, it can be a compilation of data, it can be a computer program, it could be a device. So it's really just something that gives you a commercial advantage and something that's unique to your business that you keep under wraps, or take efforts to keep from getting out to the general public, or your competitors. So how does something qualify as a trade secret? As you see that I list kind of the 3 requirements that you need to meet in order for something to qualify as a trade secret. So I'll just hit on each in quick bullet point fashion. So first, the information must actually be economically or commercially valuable. That is, what you are seeking to protect must convey some kind of economic benefit to the holder, i.e. your business. So for example, a curated client list satisfies this requirement because the list is valuable to the competitor who may obtain it wrongfully. So think of this kind of as your secret sauce. Whatever your secret sauce is, that has commercial economic value to your business, and therefore you should be afforded the protections that it deserves. Second, and just to kind of go back to what I just mentioned, the information must be kept secret. And this requirement's a bit confusing because secret here means not widely known to the public. You don't need to keep the information you wish to protect as a trade secret absolutely secret. Obviously contractors and employees are gonna, have to have some access to it to perform their job duties and make the end product. But you have to be taking some action that keeps it from becoming widely known to the public. And that's this secrecy requirement is closely tied to the economically valuable requirement. If your competitors and the public are generally unaware of the information, then it is likely valuable to your business. And then the third requirement. The third requirement is the holder of the information must have taken some kind of precautions or reasonable steps to keep the information secret. And often you can satisfy this requirement, for example, through using NDAs or non-disclosure agreements or confidentiality agreements that prevent employees from sharing your valuable secret information. And again, the precautions you take, the steps you take to keep this information from getting out there is going to vary. It's going to be very context specific, and it's going to differ depending on what stage you're at, what industry you're in, how large your venture is. So just some things to keep in mind. So, just to rehash some of these requirements, it qualifies a trade secret, must have must be commercially valuable, and must be known to only a limited group of people, and it must be subject to reasonable steps taken to keep that information secret. So that's it on that side, I think. Okay, so again, some more examples. And as you can see, like I said, it's pretty broad protection, and you see formula, survey methods, recipes for cookies, a new invention which a patent may not be available, a particular marketing strategy that puts you ahead of the competition, a manufacturing technique that increases efficiency and helps you produce more volume than competitors in your field, different computer algorithms that you use to streamline and better your workflows. So as you can see, it's really broad in what can be captured under trade secrets. And that's why whenever my first meeting with first-time entrepreneurs or small business owners, and they're discussing all these different ways they can protect themselves, I always lead them to just, inform themselves a little more on this subject, because it can capture a lot of different things you already have that you didn't know were valuable and worth protecting. And then at the bottom, another benefit of this type of protection is you don't need to register with the government to secure the trade secret. You just can simply keep the information under wraps and meet those 3 requirements that we discussed on the previous slide, and you're afforded that protection. And also, trade secrets last for as long as the secret is kept confidential. There's no limitation period. So if you have a trade secret that you keep under wraps from start today, 100, 150 years from now, when the second, third generations running your business, that trade secret can still be valid. And we see that, a great example, and probably the most famous example, is the Coca-Cola formula. I don't know if anyone's familiar with the Coca-Cola formula. They have some crazy things in place in order to keep that secret under wraps. I believe last time I was looking into it, only 2 people on the planet ever know it at once. They're not allowed to travel together. They're not allowed to get on the same plane together. They make sure they keep those 2 individuals that know this secret totally separate and protected, in order to protect, obviously, the most valuable trade secret in the world probably right now. But then in that same vein, I note there at the end, once the trade secret's made public, once the cat's out of the bag, that's really where it ends, unless you can kind of show that it was misappropriated or it was some way unlawfully disclosed, as we're going to hop into and briefly discuss on the next slide. Oh, excuse me, I misspoke. Not this. We have a question quick to make sure everyone's paying attention on this. So what is not a famous trade secret? I guess I already kind of eliminated one of the answers in my example in the previous slide. So we have 4 different things here. Some of the most widely known trade secrets. So what is not a famous trade secret? We have the Coca-Cola formula, which I kind of gave you the answer. The Google search algorithm, KFC's original recipe, and then the first Apple computer. So I'll just go ahead. I see Jocelyn put the poll up there. Why don't you go in and submit your answer, and we'll see how you did so far. Yeah. Oh, I see, Jocelyn. So this has both of them. So we're gonna have to answer both.
Yeah, I didn't realize it was going to do that. I apologize, guys.
No worries.
All right, we have a couple answers coming in. So why don't you go over the correct one?
So we're going to spill the beans. So what is not a famous trade secret? If you guessed the first Apple computer, you'd be right. The other three are some of the most famous trade secrets still to date, still being kept under wraps and heavily guarded and protected by their organizations. And the first Apple computer, as we'll discuss on later, was patented back in the, I'm going to venture to guess, probably about the 60s. I don't really know. But yeah, that's, if you guess the first Apple computer, well done. Cool. So how can a business enforce its trade secret? So first, let me back up a little bit. So what is trade secret misappropriation? So trade secret misappropriation is pretty much just legalese that simply means that some bad actor stole your business's valuable information and either used it or disclosed it in a way that harmed your business. So if that was to happen to you, if you had a trade secret and someone was to misappropriate it, how can you enforce your rights? So every state, including Pennsylvania, which I'm assuming a majority of our participants are from today, Pennsylvania has a Trade Secret Protection Act that traces the Uniform Trade Secrets Act. So if you have a trade secret, if it's misappropriated, you can enforce rights against someone who steals that confidential information by asking the court to issue what's called an injunction, which prevents further disclosure or use of that secret. And then, if it's to the extent where you're severely harmed, you can seek damages for economic injuries suffered as a result of that improper action. So if it was misappropriated, just know that you do have recourse and you do have relief that you're able to seek. But trade secret infringement lawsuits, they do have requirements that you must show to be successful, and I list them both here. You have to show that the alleged confidential or that information that they misappropriated provides a competitive advantage. You have to show that it gives you a leg up over competition. You can't just, if it's information that's just widely known or publicly available that anyone can grab onto, again, that's really not going to meet the requirements. So you have to show that it's confidential and that it gives you some type of competitive advantage. And then you also have to show that it was maintained in secrecy. And this goes back to the requirements we discussed a few slides ago. You have to show that you were taking reasonable steps to keep it under wraps, to only make sure it was known by a few select people who needed to know that information. So a lot of these misappropriations arise in the employee context. If an employee is heavily in your organization and knows some of your trade secrets, and then the relationship turns sour and they end up leaving, they might try to harm you by letting the cat out of the bag and sharing your secret sauce with the world. So just those two requirements to keep in mind if you do find yourself needing to seek some court intervention to enforce some of your trade secret rights. You got to show it's competitive, it gives you a competitive advantage, and that it was maintained in secrecy through some of those reasonable steps we discussed previously. And then lastly, I guess not so much a requirement, but something that you also have to kind of show if you're going to be successful. You have to show that it was either improperly acquired, or that it was improperly disclosed. So someone who wasn't supposed to have access somehow got access, or someone who had access and was under their obligation not to disclose it, let the cat out of the bag. So you got to kind of show where that bad actor or how that bad actor came into contact with this information, either by their own acquisition or improperly disclosing it. I think that's all I have for that one. All right, so that's it for trade secrets. I'll pause there for a second. I don't know if there's any questions in the chat, or if there's anything someone wants to hop in and throw there before we move on to trademarks.
Okay, so we have, why would you still want a confidentiality agreement if this law exists?
Good question. I would say it's just layers of protection. You also have recourse in law, but a confidentiality agreement also gives you another avenue to take. They breached the confidentiality agreement and they went against the trade secret law. So that gives you an extra layer of protection. They kind of work hand in hand as opposed to being mutually exclusive. So I always advise people to, and again, it's going to be a little specific to your organization. If you are working on some really complex technology, you're going to want to layer that up. You're going to want to have confidentialities in multiple different agreements on top of the protections you're going to find in law. So yeah, my answer to that is, why would you want this in place, or why would you want a confidentiality if this exists? Just to kind of give you that extra layer of protection and give you different options if something was to arise or you need to seek some recourse.
Okay, no other questions right now if you want to move on.
Cool. Let me just take a sip of water. It's the most I talked in a while. All right, trademarks. Trademarks is the form of protection I find most people are familiar with to some extent. And trademarks are becoming, just like trade secrets, all forms of IP, I should say, just becoming increasingly more important, especially everything keeps shifting online. And trademarks, so what is a trademark? A trademark is a word, phrase, symbol, and/or design that identifies and distinguishes the source of goods from those of another. Source of goods or services, I should say. So this is your brand. And, whether you like it or not, all businesses have brands, all people have brands, and trademarks give you a way to protect your brand and monetize your brand. So, in principle, the registering for a trademark will confer, an exclusive right to use that registered trademark. And that implies that it can be used by its owner. It can be monetized another way through licensing deals, or if it gets to the point where you're looking to take another direction for organization, you can even sell that as an asset. So trademarks are very important. And again, it comes back to brand recognition, brand loyalty, and brand protection. Consumers are very knowledgeable these days, and brands, they like to do business with brands they trust, brands that resonate with them, brands that support their values. So people are really starting to hone in on utilizing trademarks, making sure their brands are locked up to make sure they're getting the most commercial valuable out of these. And then I also know there are service mark, which is pretty much just a trademark for services rather than goods. You won't really, in the practical sense, you won't really hear the distinction. I don't really use the distinction. I trademarks, they protect source of goods or services, but service marks you may hear come up. So I just wanted to put that there just in case it was to ever arise. So there's kind of three different levels of trademark protection. You have common law rights, you have federal registration, and you have international registration. So common law trademark rights arise as soon as you put that a word, phrase, or symbol, as soon as you use it in the commercial environment. As soon as you start, if you're utilizing a logo or a name to start a business, as soon as you start that business, start selling to your customers, you're going to be afforded trademark protection on whether it be your name or logo. Now, it's important to note that common law rights only give you protection within the borders of that state. So, for example, if I'm a Pennsylvania sole proprietor, I'm doing business under, Frankie Photos, doing photography. As soon as I start conducting business, I have common law trademark rights over Frankie Photos. And there is means you can also file in the state. I don't usually advise my clients to do this because it is just an extra fee and you really don't get any broader protection. But on the flip side, there is the benefit of filing in the state because it creates a record. If an infringement action was to arise, they'll have record that Frankie started using this name back in January. Now this guy is starting to use it in March. Obviously, Frankie was the first one here. So just something to think about there. But common law rights automatically arise once you start using your name, logo, whatever it may be in commerce, and it only applies to the state that you started in. And then there's the next level, which is federal registration. And in order to federally register for a trademark, you have to go through the USPTO, which is the United States Patent and Trademark Office. And if you are successful in getting federal trademark registration, that gives you broad protection throughout the country. And there are a few different ways there's a few different options they have. The most common I run to is just the basic word mark, which seems to give you the broadest protection of that word. If again you see Google here, Google's a federally registered trademark, but they just have the word Google in black and white registered. But it gives you such broad protection that Google in any shape, form, or you see the different color scheme is encompassed within that protection. Some people like to also register their logo. I sometimes advise against it because, again, this ties into brand recognition, and brand recognition is more so tied to the name rather than a logo, unless you're something like you see here, like Nike or Apple. But logo protection is much more narrow than basic word protection. Logo protection just protects the logo in its current form. So take Apple there. If Apple filed for that logo protection at the federal level, it only protects it in that form, in the transparent form. You see it there. If they were a few years to decide to make it black or blue, whatever it may be, that wouldn't be encompassed within that protection. So at the federal level, again, you're gonna have to go through the USPTO. You're gonna have to pay the filing fee, which I believe they're going up. Last I checked, it was $225 per class of goods or services. And the process usually takes between about 6 to 8 months to get full registration. And then the last form of registration, again, this is really for major businesses that are now they reach the scale where they're now hopping outside the U.S. borders, and that's going to be international registration. I won't dive too far into it, but if you are looking to explore that route, you're going to want to look up WIPO, WIPO, which is the World Intellectual Property Organization, and that's where you'll be able to get all the information and some good resource on how you can protect your intellectual property or your trademark outside of the United States borders. So that's trademarks. It's on that slide. Okay, so this is a good slide. So why are trademarks so important? I already touched on some of the examples, and again, it's really brand. It's all about the brand. Brand has become an increasingly used buzzword, and you can't overstate how important it is. So I list some 5 reasons why I feel trademarks are so important to business. Number 1, it's an effective communication tool. Trademarks can convey your intellectual and emotional attributes and messages about you, the company, your reputation, products, services, your mission and values. So when a single, name or logo, a lot gets communicated in that. 2, it makes it easier for customers to find you. Again, differentiating yourself, making you stand out, making sure people know where this good or service is coming from. Because like I say right there, the marketplace is crowded, and especially being how much business is done online, it's easy to get lost in the competitive marketplace. Sorry, my email keeps popping up and minimizing my screen. All right, number 3, it helps in your social media efforts, these all kind of sound similar. It all ties back into brand. Social media is where a majority of advertising happens now, and your brand is the first thing customers enter into a search bar when they're looking for you. Be it Facebook, Twitter, Instagram, whatever platform they're coming to find you. It's gonna be the first thing they do is type in your name. They're gonna look for either the name that stands out or your logo that accompanies it. So it's definitely helpful in that regard. Number 4, trademarks, just like all forms of IP, is a valuable asset. And they're going to appreciate in value over time as your business grows, as your business becomes more successful. That trademark or other form of intellectual property is going to appreciate with it. So think of it as another way to monetize, and if it comes down to it, you have a valuable asset that you can do a lot with. And number 5, trademarks. This is often a misunderstood concept. Is they don't expire so long as you keep up with your post-registration maintenance documents. And this is specific to the federal level, which is where a majority of my clients seem to like to file at, because again, everything's on the internet. You're going to be at least hopping outside your state. You might not be hopping outside the country, but you're likely to be doing business across state lines. So most people go right to the federal level to get that broad protection. So number 5, it doesn't expire so long as you keep up with your post-maintenance. And what that means is once you have your filing, got this official certificate that you have that trademark for whatever it be, your logo, your name, as long as you keep up with those maintenance, which is a couple filings every few years, it won't expire. So you'll be keep afforded those protections. And like I said, that's truly valuable, because as your business grows, that asset's just appreciating and just coming along with you, and just it's just another tool in your toolbox. I like to tell people. So just some of the reasons that trademarks are so important in today's business context. So to wrap up my piece on this, important points to remember in terms of trademarks. Brands are a critical asset. I've said this a few times, and I want that to stick to you guys. Brands are a critical asset, but do your due diligence before investing a lot of time and money in launching a new brand, and be sure that the brand fits your company, it fits your values, it fits your mission, and it resonates with the target market you're going after. And this is an important point that often people overlook. Make sure you do a clearance search. So often people put the cart in front of the horse in terms of launching their brand, and then they come to find out somebody has the claim to that, and then before you know it, they're getting a cease and desist letter in the mail. So again, failure to research before adopting can lead to denial, or worse, a cease and desist letter from another brand owner. So spending the time and money up front to determine when it's available will save you the headaches down the road. And just another important point to keep in mind, the more you differentiate your brand from the others, the easier it'll be to protect. So choose a name and logo that's distinctly identify your business and who you are, what you stand for, and it will protect it from the competitors. I think that's all. That's all for me. All right, so that's all for me. I don't know if anyone has a question on trademarks real quick before I pass it on to Stephen. He's going to cover copyrights and patents. I don't know if there's anything in the chat.
Yep, nothing in the chat right now. So anybody, if you do have questions, feel free to drop it in. But in the essence of time, we are going to move over to Stephen.
Perfect. All right, Stephen, all yours.
Great. Thank you so much, Frank, and thank you so much, Jocelyn. So in the next IP topic we'll be discussing today are copyrights. So a copyright, or the author's right, is a legal term used to describe a right that a creator has over their literary and artistic works. So some common examples of the works covered by copyright are listed in point 2 here, such as books and ranging all the way to software. So to actually obtain a copyright on one of these literary or artistic works, the legal requirements include an original work of authorship fixed in a tangible medium of expression. So how I like to think of it is putting pen to paper. So if you are the original author of, say, a poem, and you are the first person to write it down, you have a copyright because that work is now fixed in a tangible medium. So you may actually have an unregistered copyright and not even know it. And the exclusive right granted by the Copyright Act for a copyright pretty much covers that exclusive right and is only limited by the fair use doctrine. So what fair use means is it permits the unlicensed use, you don't have to get the copyright owner's consent, to use the work for certain types of uses, such as news reporting, teaching, and research. So for this reason, this is why you can use a copyrighted textbook in your classroom as a professor or a teacher. So in determining whether a copyrighted work was fairly used without the copyright owner's consent, federal courts looked at a couple factors to be aware of. So first is the purpose and character of the use, and whether it was for a commercial purpose or a nonprofit educational purpose. So using the copyrighted textbook as an example, using a book for a nonprofit educational purpose is more likely to be a fair use than to sell a copyrighted book that you do not own. And one of the other fair use factors is the amount and substantiality of the portion of the work used. So as an example, if you have a copyright to a particular song and then someone uses that song entirely outright, that is much less likely to be a fair use. But if someone uses one line of that song, that's more likely to be a fair use. So the last point on this slide about copyrights are unregistered versus registered copyrights. So as I mentioned, once you put pen to paper or record a musical recording, etc., you may have an unregistered copyright. But to really capitalize on that right, you want to register with the US Copyright Office. So that process is pretty simple. Once you're registered, that enables you to enforce your exclusive right in litigation. And it's only a $45 fee to go ahead and register that copyright. And also, another benefit to registering your copyright is that it makes it easier to ascertain when the work was actually created or when it became pen to paper. And it keeps a detailed record of them at the Copyright Office. So the term of a copyright is 70 years after the author's life. And this is a non-renewable period, contrary to trademarks, which can be potentially infinite in terms of time. And lastly, I just want to talk about one hot button issue in copyrights. So over the past several years, celebrities like LeBron, for instance, has talked about the tattoos on his body. And when he talks about his tattoos, he believes, along with other people, naturally, that if they're on your body, you own them. But interestingly, what the Copyright Office and what federal courts have pretty much determined are that as long as the work is original to the author, it's the tattoo artist who actually owns the rights to the tattoos that are on a fixed tangible medium, a person's body. So I've found that interesting in my practice and in my copyright course in examining, whether who actually owns a copyright to a tattoo. So that is it on copyright. And the next topic I'll be moving to are patents, which is the area that I have the most experience with. So a patent is an exclusive right for a 20-year period granted on an invention. So much like copyrights, it's a non-renewable period for the same patent application, but there are certain strategic ways in which you can have related patent applications that can affect the term of protection on your invention. So the exclusive right granted on a patent is the right to exclude others from making, using, offering for sale, or selling the invention without the patent owner's consent. So once a person obtains a patent, they have control of how or whether others can actually practice the invention. So in exchange for this exclusive right, the patent owner makes technical information about the invention publicly available in the published patent application. So referring back to the trade secret topic that we discussed before, it's opposite, wherein a trade secret is meant to keep information under wraps, but instead for a patent, you must make all information about the invention available. And the requirements that you have to satisfy are adequately describing the invention such that a person of ordinary skill in the art, so for example, if it's a chemical invention, a chemist may be the level of ordinary skill. And you must enable that person of ordinary skill in the art to make and use the invention and disclose the best known mode of making and using the invention. So all information that pertains to your invention has to be disclosed to the patent office, and it will be published for anyone to see. So one of the things I found most interesting about patent law is once I get to the statutory categories, as long as you can describe the invention using words and figures to satisfy the patent law in that published patent document, you don't ever actually have to make a prototype of your invention. So I thought that was extremely interesting and something that was probably a misconception. It definitely was a misconception to me before going to law school. So I just found that interesting. So now that we know that a patent is an exclusive right in exchange for a disclosure of information, let's see what categories can actually be patented. So the law on this is extremely clear, and it actually hasn't changed much since 1793. So since then, the patent law has said that processes or methods, machines, composition of matter, articles of manufacture, and an improvement of those categories are patent eligible subject matter. So to prove the point, the law does not treat a granted patent on a method of swinging on a swing as any less deserving of a patent than a Pfizer granted patent on a method of determining the risk of prostate cancer. So as long as it's a process, machine, article of manufacture, or composition of matter, it could be patent eligible. So when I talked about copyrights, one of the copyrightable subject matters are software. And interestingly, it also overlaps with patent law because a method or process implementing software is also patent eligible. So in addition to the statutory categories, the invention must be new, non-obvious, and useful to a person of ordinary skill in the art. So when it means new, it doesn't mean that you can come up with the invention and it becomes patent eligible right away. So it actually used to before 2013, where it was a first to invent system. So if you invented the new statutory category first, you had superior rights to obtaining a patent. But now it's a first to file system, which means you also have to put pen to paper once you have your intellectual creation. In addition to being new, the invention must be non-obvious. So at a high level, non-obvious to you and me does not mean the same thing under patent law. Obviousness under the patent law is whether the differences between the new invention and other inventions already patented would be obvious to a person of ordinary skill in the art. So using the chemistry example again, if a chemist created a new chemical composition, it may not be obvious to me or you, but it may be obvious to a person of ordinary skill in the art. And the most important thing and the most highly contested point in patent law is whether it's obvious in hindsight. So if a patent application that discloses all of the information possible about the invention solves the problem, sure, it seems easy and it seems obvious now in hindsight, but what a patent examiner has to do is examine whether the problem could be solved before they had the luxury of the information in the patent document. So the 4 statutory categories are extremely broad and they really cover a lot, such as a method of swinging on a swing. There are also some categories that cannot be patented. So if it's outside of the 4 categories, and also a judicial exception. So these are exceptions that the Supreme Court created and said, this area of subject matter is not worthy of an exclusive right. It's actually meant for everyone. So these are abstract ideas, laws of nature, and natural phenomena. So this is the last point on this slide. We're going to turn to a question next. So quickly, I'll just read the question and you'll see the answer choices. Based on the 4 statutory categories and those brief judicial exceptions, which of the following here is patent eligible subject matter? Just give a few seconds for everyone to answer.
Yeah, Steve, sorry, we're not going to be able to run the poll. I messed up when I put it together, but just, go
Sure.
with it.
Okay, sure. So for this question, the correct answer is B, a method utilizing a new scientific principle. And to dispel another misconception that I also was under before going to law school and taking patent courses, is that Einstein's E equals mc squared is not patent eligible. That equation of special relativity is reserved for everyone, and it's a judicial exception, and no one gets the exclusive right to that. And same with C and D. Next slide, please. So very quickly, there are 3 types of patent applications, but far and away, the most popular application is a utility application that covers the function of an invention. So breaking that down even further, there are provisional and non-provisional applications. So when applying for a patent under that first to file system, it's important to get your idea on paper and filed to the Patent and Trademark Office as soon as possible. So with that said, I typically advise my clients, as do other patent practitioners, to file a provisional application first. So a provisional application has fewer formal requirements and is a placeholder that actually gives you 1 year in order to file a non-provisional, which is a formal application at the USPTO. So this is especially important under the first to file system, getting something on paper and filed as soon as possible. Next is a design patent, and these cover the ornamental design of an article of manufacture. So the way something looks entirely. So this is a fairly common patent area too, but far and away the utility, the way something functions, is the most popular. And very, very briefly and very seldom used at the patent office are plant patents. And this grants the exclusive right to whoever has invented or discovered and asexually reproduced a new and distinct variety of plant. Next slide, please. So in talking about utility and design patents, this is a topic that I learned in my patent class that was extremely interesting to me. So this is one of the ways where you can actually have two applications covering the same invention. So on this slide, I show the cover sheet of the granted patent documents, and the one on the left covers the function of a golf club head, and the one on the right is a design patent covering the ornamental design of that same club head. So this is one way that Cobra Golf, the owner of these golf patents, has really utilized the patent system and made the most of it and covered two different aspects of the same invention. So this is the last I'm talking about patents. Thank you.
Okay, so Frank, I don't know if you want to close it up and then we'll turn it over to Penn State. Oh, you're on mute.
Am I still on mute?
Nope, you're good.
Still on mute. Okay, cool. All right, so that's that's a brief overview of the four types. Hope it was very informative. As you can see, some of them are a little less complex in terms of trade secrets, copyrights, trademarks, and then as you see, patents are very complex. I give Stephen kudos for doing patents, right? I needed a dictionary for the first 8 months of my patent course in law school, so it's definitely a complex area. So yeah, so as we touched on, it's a mix of state and federal law, and they do apply to every business. So definitely pay some more attention and think of how you can protect and exploit your intellectual property for your venture, your small business. And then that's all I got. I'll pass it over to I just saw a question pop up. I don't know if I want to take that.
Yeah, let's see. Okay, so the question is about using clip art. If you begin with a piece of clip art, assuming it is either public use or you purchased it, if you alter it, add to it, customize it, does it become your property?
That's a great question. So with the fair use factors, in that case, looking at an image, what would happen is they would look at the image and they would determine whether this is substantially the same as a clip art logo. And a clip art logo is owned by Microsoft Office or whichever company. So if you develop the logo into something that seems more new, a court, if it were ever contested, would see that, okay, is this different enough? And is this for an educational purpose, or is it for commercial purpose, or things like that? And under that landscape, they would analyze whether this is sufficiently the same or not.
Okay, and then it looks like we had another question asking if all patents are the same cost or are there different cost associations with patents?
Sure. Thanks, Abel, for that question. So in short, the patent application does cost the same. So in terms of legal fees to the U.S. Patent and Trademark Office. So in terms of what the cost is for a provisional application, that's $75. And for a non-provisional examination, that costs $455. So those are the basic filing fees in terms of the patent application process. But in terms of the subject matter, it sort of depends on the complexity of the invention. So for instance, a simple mechanical device, such as a hammer that's new and useful and innovative versus a new pharmaceutical composition may require more legal fees from the patent practitioner. But in terms of the USPTO fees, they remain the same. And actually for individual inventors, the USPTO incentivizes those inventors by providing discounts on the filing fees. So the fees that I mentioned are the most discounted fees, as opposed to, say, a large pharmaceutical company that pays the highest level of fees.
Okay, this is last question for now, then we're gonna turn it over to our other panelist, Kelly. The question is, if you own a patent, trademark, or copyright, can you assign or license that right to others?
Yeah. that's really that's one of the main reasons I always advise my clients to really think about this. Because if no other reason, if you figure out, this brand or whatever form of IP you have isn't in your business strategy or no longer in your interest, gives you an avenue right there. You can assign it, catch a fee. You can license it, catch a fee. It's it's a source of revenue, and it's just another asset that you protected and can't exploit.
Okay, wonderful. So for now, we're going to hold questions, but feel free to keep dropping them in the chat. We can answer them after we turn it over to Kelly Henry. So thank you so much, Frank and Stephen, for being here. Feel free to stay on in case there's some questions later. I am going to stop sharing the screen for now, and we are going to spotlight Miss Kelly Henry. Kelly, and I apologize that I did not receive a bio from you ahead of time. So if you want to just take a couple of minutes to talk about, who you are and where you come from, and then maybe talk about the Intellectual Property Clinic and how they can help.
Sure. So my name is Kelly Henry. I am in my 3rd year at Penn State Law. I'm actually close to the Hazleton area. I grew up around Bloomsburg in Catawissa, so pretty close. And then I went to IUP for undergrad, and now I'm at Penn State Law. And I have now been in the IP clinic for 3 semesters, so I have a little bit of interworkings to how the IP clinic works and everything. So a little bit about our clinic. So basically everything that Frank and Stephen were saying, we do. So we counsel clients on patent matters, trademark matters, copyright matters, and trade secret matters. And we do it all for free. We are underneath our director, who is a registered patent attorney, Professor Andrew Sherman, and then we also have a staff attorney, Asley. And they are both barred attorneys, so we work underneath them, and that's how we maintain free services. Now, the one thing I will say is that we do require our clients to pay for the fees with the USPTO. So you would be still responsible for those fees that Stephen and Frank were both talking about, associated with patents and trademarks. And then if you file a copyright within the Copyright Office, which is a different office from that, which kind of gets confusing. But so that's a little bit about our clinic, and we are a little bit slower with our wait list right now. So I'm going to put into the chat where you can sign up for our application, and we serve everyone within Pennsylvania and anyone that's affiliated with Penn State. So if you have any questions about that, that would be great. If not, that's perfect too.
Great, thank you, Kelly.
Yeah, thank you, Kelly.
Okay, so I'm going to remove Kelly's spotlight. We should all be in a gallery format. I don't see any additional questions coming through right now, but we'll give them some time. A couple of things that I want to point out with Kelly, you being here, we refer to the Penn State Intellectual Property and the Penn State Legal Clinic quite often. So can you maybe touch on the difference between the legal clinic and the intellectual property clinic, and what type of client would go where?
Awesome. Yeah, sure. So we actually, if we were in person, we would be within the Happy Valley Launch Box, and the other clinic that works out of the Happy Valley Launch Box is the EAC, which is the Entrepreneur Assistantship Clinic. And they basically do corporate matters. So if you need to file an LLC, they will handle that, or any corporate type of work, that they'll do that aspect. But with our IP clinic, what we do is basically the counseling of the IP matters. So it just goes back to the trademarks. We do licensing sometimes, copyrights, that type of stuff. So we're mostly that area where they do the formation issues, the corporate issues, the contract issues.
Wonderful, thank you. So, and again, I know that we have some people that are clients of the Launchbox, the Hazleton Launchbox. So we're thrilled to have them on here as well. And I know that Bill Andahazy and Furman Diaz also refer to both of those clinics quite often, as well as our Small Business Development Center that's housed out of Wilkes University. So, these are tools that we use regularly. This, so if you're a business that's on this call and you have questions about how you can reach out to the clinic, feel free to reach out to myself, and I can get you in the right direction. I'll put my contact information in the chat. We do have another question, and I believe this is probably for Kelly. Does the IP clinic have any guidelines that they can make available for filing a provisional patent? Actually say, I'm sorry, Kelly, I'll let you answer, but I would say after Kelly, Frank and Stephen, if you had any information of public information that you could also, follow up with the responses of that as well.
So, sorry, I didn't mean to interrupt, but basically with the provisional patent, we do also recommend, we recommend filing a provisional patent before filing a non-provisional as well, as Stephen was mentioning earlier. But not necessarily do we have any guidelines in the sense, mostly like kind of what Stephen was talking about, that it has to be novel, that it has to be non-obvious and everything. But what we will do is what's called a patentability search, which is where we go through and we try and find other prior art that's out there. So that can be anything from other patents, non-patent literature, which can be anything from dissertations, theses, journal articles, anything basically that would have that same idea as what you're looking at to file on. And we'll do that whole analysis and we'll look at all of everything that's out there to determine if you even have a patentable invention. Because not all inventions are patentable, just in the sense like there might be something out there, even in another country. It's not just selective to the United States. So that was a little bit of the analysis that we'll do. And we also, with the trademarks, going on a little bit more about that, is we also do trademark clearance searches just to determine what else is out there so that you have an idea of like when you're branding and stuff like that.
Great, thank you. Stephen or Frank, anything to add to that?
Yeah, I mean, just to kind of continue on that, I mean, go to the source. The USPTO's website is packed with information, be it FAQs or kind of walkthrough tutorials, in long form or short form. So if you want some background or good place to start, I always tell people is go to the USPTO website and like I said, they have a ton of resources, all free. And that will give you a good starting point to kind of start formulating some ideas, brainstorming, and really putting a plan in place. Really starting to refine that before you approach an attorney or a clinic, whichever route you take. So yeah, that's kind of my only advice right from the get-go. Check out the USPTO's website. You'll be able to get some background info.
Great. What about you, Stephen? Anything to add?
Great. Just to mention that Kelly had a great point about doing a patentability search. So while it's not required, that's something that I, along with glad to see that many patent practitioners recommend definitely doing this first before spending money afterwards. So I definitely am in complete agreement with doing a patentability search and opinion first.
And even just one more quick point on that. Doing the legwork before is going to save you so many headaches down the road. So many people come to me after the fact. And like I said, once the cat's out of the bag, it's really hard it's just going to create more cost and it's going to more legwork to fix things. So really take care of the initial steps, just doing your search, thoroughly searching. And even a good place to start, I always tell people, is a Google search. If you're thinking of a brand name or thinking of an invention, type it in Google, see if it's out there, and then get more detailed with the USPTO search portals, and then maybe get the assistance of a practitioner.
Okay, thank you. All right, we still have, we have a little bit of time for questions. We're up on the hour. It's 2 o'clock. While we're waiting to see if anybody else drops questions in the chats, I want to thank everybody for being here. Kelly, I know you were kind of thrust into this week, so thank you so much for making the time to be with us. The Penn State clinics, both intellectual property and the Entrepreneurial Assistance Clinic, are extremely beneficial to Pennsylvanians all across the Commonwealth. So thank you for the work that you guys do there. And I certainly enjoy referring clients over to you. Stephen and Frank, again, thank you so much for being here. best of luck with all of your endeavors. Stephen, I hope you hear from from the New York bar soon. And I'm sure that you will do wonderful in your upcoming career. And Frank, we are thrilled to have you representing the Hazleton community, of course, both here and in Philadelphia as well. So thank you so much for being here. Anybody who wants to see this presentation again or reference the slides in the future, we will be uploading it to our YouTube page. I will share that with all the presenters if they want to share that on their feeds as well. So thank you again. Thank you for being here. I don't see any more questions coming in, so I will bid you adieu. Thank you for being here.
Thank you, Jocelyn. Thank you again for setting us up and moderating.
Yep, thank you so much.
Thank you.
Thank you.
Have a good day, everyone.
You as well.